Welcome to our viewing audience to episode 3, Discipline Costs Revisited, Who Should Pay the Price? My name is Claire Billick, and I am internal counsel with CPA Nova Scotia. I am joined by Greg Sim of Field Law here in Alberta and Jean-Claude Killy with Palliere Rowland in Toronto. This episode is going to discuss the recent Court of Appeal case from here in Alberta, released in the summer, called Charkhandeh and the College of Dental Surgeons, which significantly redefines the approach to costs awards in professional discipline decisions in Alberta. It abandons the framework imposed in the 2022 GINA decision, which established a presumption that against the idea that the profession should have costs awarded to them when they're successful in discipline hearing decisions in cases of professional misconduct. The Charkhandeh decision provides new guidance on factors to consider regarding costs awards. Greg, can you refresh our memories about the GINA decision and how this Charkhandeh decision changes the approach in Alberta?
Sure, thanks, Claire. The GINA decision was also a decision of the Alberta Court of Appeal coming out of the College of Dental Surgeons of Alberta. And in the GINA decision, the Court of Appeal departed from its previous case law that used a series of factors to decide whether an award of costs for investigations and hearings should be made and how much those costs should be. In the GINA decision, the Court of Appeal, notwithstanding what the legislation actually says in Alberta, decided to adopt a presumption that in most cases, the profession, or in practical terms, the regulator, would pay or be responsible for most of the investigation and the hearing costs. And the Court of Appeal said that except in cases of compelling circumstances, which it defined in a series of categories, that presumption should stand. Then in 2025, the Charkhandeh case came out, and the Court of Appeal in Charkhandeh decided that it would reconsider its analysis from the GINA case. The Court of Appeal in Charkhandeh looked at the legislation, used principles of statutory interpretation, and said there shouldn't be a presumption. There should be no presumption that either the regulator or the registrant should bear any particular proportion of the investigation and the hearing costs. The court largely reverted to a multi-factor assessment of whether an award of costs should be made, and if so, how much. And the court gave us a number of factors, some of which were from the previous case law, including things like the number of allegations that are laid and the relative success of the parties in responding to or prosecuting those allegations, although it was clear from the court's decision that we shouldn't be using a mathematical approach. The court said we should look at the conduct of the parties, the length and duration of the process, and the details and types of those costs to assess whether those are reasonable amounts to incur and to pass on to a registrant. And the court also said we should think about the financial circumstances of registrants so as to make sure that an award of costs wouldn't dissuade someone from trying to defend themselves against allegations of unprofessional conduct.
Thank you. I find it interesting that the Alberta Court of Appeal reconsidered this approach after only 3 years.
It was a really interesting development. It was something that we applied to the court to ask them to do, knowing that the GINA case was so problematic in the way that regulators were having to try to deal with it.
Thank you. Jean-Claude, how is this Alberta decision being received in Ontario, and to the extent you can comment, elsewhere in Canada?
Well, I think the short answer is that it isn't. Dealing with the rest of Canada first, I've looked, I haven't found any discussion of GINA apart from a couple of Law Society tribunal cases in Newfoundland and Labrador that don't really discuss it. They treat it as something that was submitted to them and not really a part of their jurisprudence. In Ontario, at the tribunal level, it has now become somewhat common for defense counsel to raise either the GINA decision or now the Charkhandeh decision, which is more or less equally as useful in Ontario in the attempt to submit to tribunals that they should depart from what has been the normal approach of most tribunals in Ontario, which is to essentially presume that when there's been a finding of misconduct, the member who's found guilty of misconduct is going to bear some amount of costs for the proceeding. At the divisional court level, which hears the appeals in Ontario from most discipline tribunals, the divisional court has expressly dealt with GINA and noted that it's not particularly persuasive to them and inconsistent with the approach in Ontario, and so it's not an error or a problem for tribunals to depart from it. The divisional court's approach has fairly consistently been deferential to the approach of the tribunals. And the approach of the tribunals is not, from a principle perspective, it's somewhat consistent in Ontario in that there is often a presumption that the member guilty of misconduct will bear some amount of costs, but the extent to which colleges seek costs and how far they go in seeking their actual costs versus any costs at all is quite variable depending on the tribunal and the profession. So at the nurses, they routinely don't seek costs unless there's been conduct that has wasted costs, a late settlement, irrelevant evidence, that kind of thing. At other tribunals, they routinely seek somewhere between 60 and 100% of their actual costs. It's really dependent on issues that are particular to that profession, which I think only reinforces the extent to which the divisional court is likely to continue to be deferential to the tribunals in how they approach costs.
So in Ontario, it seems though that this Charkhandeh case is consistent then with your approach or in your province in terms of principles.
No, I think it's not consistent in the sense that the Alberta Court of Appeal in Charkhandeh pretty clearly says there's no presumption built into the legislation, and so the tribunal should approach the question without a presumption. And it's an error to have a presumption as to which party will bear the cost. And that's how they depart from GINA, I think, is by saying that GINA, the presumption was the profession bears the costs. Yes. That doesn't apply either. I don't see a lot of the holdings and principles articulated in Charkhandeh as very likely to have a lot of uptake in Ontario for that reason, that they don't resonate with the jurisprudence that has come out of those tribunals, and so it's going to be difficult to integrate in the jurisprudence in Ontario.
Okay, thank you. What lessons can regulators take from this decision to apply to their management of discipline hearings going forward?
You know, Claire, I think one of the interesting things that regulators can take from this is the amount of supervision the courts seem to be saying they want to exercise over this aspect of professional regulation. This, to me, represents a retreat from the amount of deference the courts had previously said they should give to regulators on issues like this. But for the takeaways, to my mind, regulators will need to be thinking about how to best record and document the kinds of costs that they're incurring for their investigations and their hearings, and then how to best produce that information so it's easy to use and understand for discipline tribunals, appeal panels, and ultimately for the courts.
And do you have any additional lessons that you can see just from your own experience in Ontario?
I think Greg's lesson is one that a lot of regulators should take to heart. The recording, the foresight at the front end of thinking through how costs are going to be tracked and what the submission is going to be at the end of the day for recovery of costs is very important. I think what Greg hit on about the Alberta courts indicating their willingness to supervise at a granular level the costs is really the core of the departure from Ontario, where the divisional court has signaled its general unwillingness to supervise the costs to that degree, provided that the tribunal has explained itself and articulated something coherent. So the one thing I said, I think last time, that I didn't see a lot of principles in Charkhandeh likely to be taken up in Ontario. The one that concerns me from the regulator's perspective is the observation that in the tribunal world, the costs regime is a one-way cost regime. There is generally not an ability to award costs against the college, except in very specific and unusual cases. And all of the other jurisprudence in the civil context about costs speaks so much about incentives and incentivizing reasonable litigation behavior and that doesn't apply very well in the one-sided cost regime. At least it doesn't apply to the college. And so I think that regulators have to really internalize their public interest stance and think through how they're going to present the reasonableness of their costs request in the context of their profession and their tribunal. And they have to keep in mind that the tribunal is their audience, because the courts have signaled a lack of interest in detailed supervision. So if you lose, the flip side of the divisional court saying that the costs are discretionary and the tribunal did something consistent with the jurisprudence, is that if you as the regulator lose the tribunal and the tribunal comes in and says this was excessive, you shouldn't be charging all of this, you shouldn't have had a 25-year lawyer on this case, etc., don't expect the divisional court to bail you out on the appeal, because that's really the flip side, I think. So you have to have the reasonableness, the sort of the incentive, that aspect of the cost regime baked into your stance as the regulator when you approach the tribunal for your costs.
That's similar in Nova Scotia as well. I think much more consistent with Ontario than with Alberta. I was interested in reading the case in the court getting into the minutia of the costs, including the presumption against receiving costs for experts who had been retained in support of the case. Do you have any insight on that?
I thought that was one of the really interesting comments the court made, because the court made a comment that the costs of experts should ordinarily not be passed along to a registrant found guilty of unprofessional conduct unless that expert report was proportional and reasonable to use in the circumstances. And to me, the interesting thing is, I guess maybe the disconnect between the court and the regulators, who would, I think, universally be saying, well, we're not going to call an expert and incur that expense and go to all that effort unless we can justify that part of the process as being necessary and reasonable. So to me, the court made a number of comments about the overall costs of proceedings and the infrastructure of hearings, but it struck me that there was a bit of a misunderstanding or a disconnect between what the court thinks regulators might be doing and what regulators are actually doing. And to Jean-Claude's point, I think regulators can take from that the need to do a bit better job communicating what goes into these sometimes very complicated and unfortunately expensive investigations and discipline proceedings.
Thank you. That's great feedback.
I agree a lot with Greg. I noted that part of the decision about experts, which strikes me as an unusual proposition to articulate on on the level of professional discipline generally, because it strikes me as very profession specific. There are some professions where, for example, if College of Early Childhood Educators, I imagine you don't need expert evidence a lot. I imagine that you can hardly prove acts of misconduct at the College of Physicians without expert evidence. It's very dependent. But what really does come through from the Charkhandeh decision is the lack of detail in what the court was provided. They really did not appear too impressed with the lack of detail and the lack of substance. There was $160,000 in preliminary applications that they wave away as sort of, nobody told us the outcome of those applications, nobody told us what went into them, so we're just not awarding costs in relation to those. I think that's an important lesson, is to come with a lot of receipts.
Thank you. Yeah, I agree. And from the regulator's perspective, that is informative, because who knows where the next court case will take us, but it looks like there may still be room to grow this jurisprudence in Alberta.
I agree.
Yeah. Any final thoughts as we wrap up?
From my perspective, the real final thought is that I'm hopeful the Charkhandeh case will now create some stability in the law of costs in Alberta, with the reversion to this multifactorial approach that we had in the previous case law. So for Alberta and perhaps the jurisdictions that are inclined to follow the Alberta case law, I'm looking forward to dealing with the minor issues, the minutiae, as opposed to the larger principles.
And Jean-Claude, any final thoughts?
Just to note that there's a final word coming, a decision of the divisional court that's been under reserve since May, that we expect pretty soon, that very squarely addresses costs, a very large, several $100,000 cost order at the College of Chiropractors that was attacked on the basis of the GINA principles. So we'll see.
Oh, we will be following that with interest. Thank you, Greg and Jean-Claude, and our virtual audience for tuning in today.
Thank you.